Welcome to Judica County. I am your host, Josh Whitaker. With me is Joe Hamer, partner at the law firm of McCullers, Whitaker, and Hamer. Today we're doing one of our Real Estate Closings 101 segments where we talk about one question that we get repeatedly. And so now we'll have a video about it when people ask us that question. But today we want to talk about residential, real property, under contract, and that contract is terminated by breach or one way or the other. And so we're just going to talk about a couple scenarios that come up a lot. And the first one, under a normal standard North Carolina offer to purchase contract as a buyer, you can negotiate a due diligence period. And usually you'll pay something for that due diligence. There'll be a fee. I've seen as low as $100, as high as $5,000. It depends on the market and the seller, how many people are interested in that property, but you'll negotiate it. And let's just say it's $1,000 and you'll pay that. Your seller has the money. And so you'll negotiate time period too. I've seen 1 week, 2 weeks, 4 weeks up until closing, but you'll negotiate a duration. So you have paid money for this due diligence fee. And you do that because that's your time to inspect the property, and you can walk away for any reason at all. You don't like the color, they painted a bedroom, you get cold feet, any reason at all, you can walk away and you are out your due diligence money. But any earnest money that's being held, you get that back. You don't get any inspection fees back under this scenario. That's it. You paid for this due diligence period, you used it, you terminated, you get your earnest money, you move on to your next house.
So you can basically split this up into two categories. The during due diligence period, assuming that there is a due diligence period, just like Josh discussed, and then everything after, assuming there is a due diligence period, everything after that, you're going to be talking about breach from either the buyer or the seller to lead to the termination of the contract. Again, you're going to have one party breaching, be it they just unilaterally decide that they're going to terminate, be it that they just drag their feet, they fall off the face of the earth, you don't hear from them anymore. We've seen every possible scenario play out, but you're going to be dealing with breach. So we can kind of further subdivide that into whether it's a breach by the seller or whether it's a breach by the buyer. So when you're talking about breach by the seller, you're going to see essentially either just refusal to perform, be it they refuse to come to closing and sign the deed, they refuse to provide information that's needed to get to closing.
Right.
Or you could have a situation where some kind of unknown title defect has sprung up and the seller just simply can't provide good title at that point.
Right.
Both of those situations are going to be breach. And regardless of whether it's the deliberate choice of the seller, they're still going to be in breach, and there's going to be consequences for that breach. So when you're talking about the seller's breach, simply put, you're talking about at minimum, the buyer is going to be able to ask for a return of any funds they've put down, including their earnest money, including appraisals, inspections, survey fees, whatever they've paid thus far, they're going to be able to ask for that back from their seller. Now, when I say they can ask for that back, they don't just ask for it back and it automatically comes to them. You're talking about a situation where you're going to have to file suit and you're going to have to ask for that reward in that suit.
I think a lot of people are surprised. They have a seller who's unwilling or unable to close. Usually a settlement agent's holding earnest money, so your earnest money is probably going to find its way back to you in that scenario. But then your due diligence, and like Joe said, inspections, that stuff you demand. You said ask. You demand. You demand it back.
Yeah.
But then again, a seller who's not been able to get to closing is not going to just probably write you a check. So you're looking at some attorney's fees, a demand letter, maybe even litigation, and I guess for better or worse, a lot of times the money you're out is under
what you're going to spend to get it back.
Yeah, you're going to be under $10, under $5, under $2,000 of damages. Your time's wasted. You're obviously very upset. But when a judge says, "Well, what are your actual damages?" they're not going to add up to a lot when you calculate what attorney's fees are. And so you kind of get into this.
You negotiate it, in essence. It's usually going to be a negotiation. So on the buyer's end of the spectrum, you're going to be looking at essentially, they've either decided to not purchase, they don't like the house anymore, something's come up, they can't do it, there's been an issue with their loan, whatever the reason may be. And the buyers are going to be looking at a similar situation where the seller can also sue for whatever monetary damages they say they've incurred as a result of this. Now, it's a little bit less cut and dry because they haven't been paying for appraisals, inspections, things like that, but they've got loss, and really they can ask and they can frame that loss however they'd like. But again, it becomes a matter of litigating it or negotiating it. So they're going to make their argument. but there are going to be consequences in that sense where there's going to be a problem and you're going to have to deal with it.
Yeah, the standard offer to purchase that most agents, most attorneys use for a residential purchase has really been tailored to kind of explain things and kind of limit, to a certain extent, liability as much as possible under like normal scenarios. But people constantly get themselves into situations that require an attorney to probably get involved and resolve. Your real estate agent's not going to be an attorney, your lender's not an attorney, and you're not an attorney. So when you get into this breach area, usually an attorney is going to need to help you. And we do a lot of closings. We try to help when we can, but it may get to a point where you need to hire an attorney to just represent you on the litigation front.
Yeah, there's only going to be so much we can do for you, especially if we're doing the closing and we've actively worked with both parties at that point. You're probably going to have to get another attorney. Now, one other situation we can talk about briefly: the standard North Carolina offer to purchase contract. There's a 14-day grace period in essence. So, and we're talking about a non-new construction situation. That would almost be its own podcast, talking about a delay in new construction. But just assuming a traditional residential purchase of real estate, there's generally going to be a 14-day good faith type of time is of the essence requirement, where if either party can't perform, whether it be the buyer can't close or the seller can't for some reason do their obligations, there's going to be a 14-day period there where after the stated settlement date, there's going to be kind of a grace period.
I will add real quick, and you were probably about to say this, but all parties have to be acting in good faith.
Yeah.
Right. So if it's a situation where your seller or your buyer's not really working with a mortgage lender, and they can't, there's certain things you may be asked for during that grace period to prove to the other side that you're acting. Yes, there's a delay. We're all sorry there's a delay, but we're working our best to get to closing. So the other side can allege bad faith and get out of the 14-day window. But yeah, there's.
But generally speaking, there's going to be there, and depending on how difficult the other party is or how the transaction's been to that point, good faith may become an issue. But assuming good faith, you got that 14 days. And one question we'll get a lot of times is, how does a contract extension affect that 14 days? And I think that kind of gets into another gray area where you could argue either way, depending on the form of that amendment, whether it was drafted by an attorney or whether it's just a standard amendment. I think there's an argument that 14-day requirement it survives.
Yeah.
It exists from the original contract, and it would still apply. But again, there's the argument. There's arguments the other way as well.
Depends on who you ask.
And again, it becomes a matter of negotiation unless you're going to take the time and the money to litigate it.
So best case scenario is avoid a contract termination situation.
Just don't breach.
Anyway, I hope that was helpful. It is just a cursory discussion about some of the questions, some of the things we see. Give us a call, 919-772-7000, if you have any questions or concerns. Otherwise, I hope this was helpful, and we'll see you next time.